Thank you, Kirsten, very much. It is 5 o'clock, so we will call this second meeting of our PSAC, our Pump Storage Advisory Committee meeting to order. And I thank everyone for being here. And there were some snacks in the kitchen, so I hope everyone has got some sustenance. And we will take a break in an hour or so that you can get a drink of water if you need to. So I will ask you all to join me in a moment of reflection. Thank you. Is there any disclosure of pecuniary interest around the table, recognizing that one can be declared at any point during the meeting should you feel the need to? And seeing none at this time. Number 4 on our agenda is public participation. So for anyone who may be tuning in, I will read this piece. Members of the public are encouraged to provide the committee with their comments and questions. Presentations must be prearranged with Kirsten Higginson, Project Administrator, Pump Storage Project, before the agenda is released. Members of the public who wish to make a deputation about a specific agenda item at the meeting must register in advance with Kirsten Higginson by 4 p.m. on June 12th, 2024 by contacting khigginson@meaford.ca or 519-538-1060, extension 1172. Presentations are limited to 10 minutes and deputations are limited to 5 minutes. So the dates were suggested there, June 12th, today being June 13th. So Kirsten just needs to know by 4 o'clock on the day before a Pump Storage Advisory Committee meeting that someone would like to present to us. So we have no presentations today and no deputations. So we'll move into adoption of the minutes. And I trust everyone has received and had an opportunity to review the minutes from our first meeting on May the 9th. So I'll ask for a mover to accept those minutes. Adam, thank you. And a seconder, Bob. And are there any questions or comments related to those minutes? And seeing none, I will ask for an all in favor to accept the minutes as presented to us. Thank you very much. Number 6 on our agenda under items for consideration is Code of Conduct training. And I want to welcome Jeff Abrams, who is our Integrity Commissioner from Principles Integrity. And he's been working with this council for a number of years. Jeff's going to tell us exactly how many, but we're really grateful to you, Jeff, for all of the advice and guidance and training you have provided to us during that time frame. And I'm going to turn the meeting over to you to take us through the Code of Conduct training. And I will just suggest that if anyone has questions throughout Jeff's presentation, please just raise your hands, because this is really important and we want everyone to be really, really comfortable with the information that you're about to hear. Over to you, Jeff.
Thank you very much, Deputy Mayor. I'm pleased to be here and pleased to be at your second meeting. I'm giving you a version of a training package that, depending on who the audience is, it could take up to 3 hours. Tonight, we're going to spend a bit of about an hour, I think. Can you hear me okay?
Absolutely.
Oh, great. We're going to spend about a bit of an hour, and that means I'm going to move kind of rapidly through portions of it. By all means, if I'm going too fast, you can call me back. If you've got a question in the moment, as the Deputy Mayor has invited you to do, interrupt me. We're going to treat this like a classroom today. And as I said, I'm going to introduce myself again in just a second. We're going to talk a little bit about the role of an integrity commissioner. I venture to think that you may not have encountered one of us in the course of your lives until now. We're going to talk about some code of conduct principles, but we're going to spend most of our time under Part D on your screen, avoidance of conflicts of interest. And of course, E, questions and answers, do that throughout. If a question pops up, if you have a comment, I'm happy to address it. Now, Principles Integrity has been the Integrity Commissioner for the municipality for quite some time. 2018, perhaps, vintage that, maybe. I could be wrong. Principles Integrity is two people, my partner Janice Atwood and myself. Both of us have come through the municipal sector. We've been lawyers. Myself, I've also been a municipal clerk. Janice and I in 2017, we happened to retire on the same day from the municipal sector. We decided to form this partnership, knowing that all municipalities in Ontario are going to need an integrity commissioner. It's required under the Municipal Act that every municipality have a code of conduct, have an integrity commissioner, and even their local boards are required to have a code of conduct and access to an integrity commissioner. More about that in a bit. The mantra of our company, you don't really have to read this word salad in detail right now. I'll tell you what it means. It means that the general perspective from people not acquainted with municipalities, the general perspective of all politicians, regrettably, is the same. People like yourselves involved in a governance process, regrettably, it's the same, and that is it's not high. The view of all of us involved in the municipal system is relatively low. Any politician, you're not too far from Donald Trump in the minds of many people. If you care to disagree with me, I'm happy to debate that point. I don't think you do disagree with me. So the point of having an integrity commissioner code of conduct is to make sure that the policies, procedures, codes of the municipality are reflective of proper ethical behavior, that you take education, that you get advice, and advice is the most important function of an integrity commissioner. More about that later too. And there's also a fair complaint mechanism available to people who are observing you and members of council and others. A fair complaint mechanism administered by us. Take all of that together and it increases the perception of integrity, which is really, really important. So that's me in a nutshell. I'm not going to go too much further because we are short of time this evening. That's me. Now let's talk about you, the Pump Storage Advisory Committee. Before I go into the technical role you play, let's talk about what your mandate says, some excerpts from your mandate. I'm hoping I can see this on screen. You're to serve the Council of Meaford as an advisory body, evaluating and reporting to Council on matters pertaining to the proposed TCE Ontario Pumped Energy Storage Project. You knew that. That's pretty evident. The committee shall be responsible for making recommendations to the CAO and Council on matters related to the pumped storage facility. You're making recommendations. You're an advisory committee and you make recommendations. And I can't recall which part of the mandate this was from, but it says a potential member, so obviously this was before you were appointed, shall not be prevented from appointment simply by virtue of being inclined for, against, or neutral on the proposed project. No declaration of position shall be required of members, but is encouraged to achieve a committee balance of members with a positive, negative, and uncommitted view of the project. Members should maintain an open and objective attitude. My apologies. So there's some signals there right in your mandate, right in the mandate that describes the committee. In fact, it welcomes a divergence of views and experiences, which is proper for an advisory committee such as yourselves. It was recognized by council, I am presuming, that you may have had a positive or a negative or a neutral or an academic or some other perspective on the project itself, given that your task is to make recommendations someday to council, which council will be free to, of course, accept or reject, separating your role, your work from council's ultimate responsibility with respect to the project. So that's that. Let's talk about integrity commissioners quite briefly. As I mentioned, every municipality is required to have an integrity commissioner. We all happen to be the integrity commissioner, not only for Meaford, but for the county and for most of the lower tier municipalities in the county. You're part of what is called a local board. It's a very broad definition under the Municipal Act. It's probably the most convoluted definition under the Municipal Act. We've got local boards for some purposes and not for other purposes. It's a bit crazy making, but you are certainly a local board. An advisory committee to council is a body. You are what is referred to as a local board. And so our role as integrity commissioner applies to you. This graphic is another way of me describing that mantra, that word salad we saw a few minutes ago, showing that we have a role. It's a very broad role. We assist the municipality in developing its policies, revising its code, conduct, that sort of thing. It's a consulting role. We provide education, just as we, the royal we, are doing this evening. We provide advice. The most important function of an integrity commissioner is to provide advice, and you'll see why in a minute or two. But we're also the complaint department. So somebody could complain to us that you've somehow breached the code of conduct or you've breached what's called the Municipal Conflict of Interest Act. We receive those complaints, we digest them, we decide whether or not we're going to investigate. We may make findings, we may not. May not make findings. If we do make findings of breach, we report to council and we may make recommendations for a sanction. And then other duties as assigned, you'll see in the lower right red corner. But this is not to be considered in a vacuum. You'll see that big blue triangle. The whole purpose here is to increase the amount of trust, respect, and engagement council, corporation, gets from the community, which is exactly the point, I would think, of having this committee give advice to council on this project. To have the trust of the community, respect of the community, to come and provide their thoughts, to have you sit around these tables and formulate your advice and to convey that to council as your best advice to council. Now, pardon me the triggering effect of this graphic. Members of council will have felt this, I'm sure, this target on their back from time to time. This particular slide speaks to what might occur if somebody were to complain under the Municipal Conflict of Interest Act about a member's inability to participate because of an interest they might hold. The point of the slide is that even though someone may take an end run and complain through the courts about the member, the court has to take into account the written advice that they or you would have received from your integrity commissioner. It's fairly hard to conceive of a court landing on any one of you for following the written advice of your integrity commissioner. That's under the MCIA, but it also applies under the code of conduct. If you are concerned, these things are complicated. You reach out to us through an email. You say, here's the situation. Is it okay if I do this or that? We look at the circumstances and we may say, yes, you can do this so long as you do this other thing. And then you do this and that other thing, and the circumstances remain the same. Nobody can then come to us and say, hey, wait a second, I think that was improper. We can't change our mind. The advice is binding. It's binding on us. In other words, it's bulletproofing for you. Essentially bulletproofing because the court doesn't have to take our advice, but I can't conceive of circumstances where they wouldn't. But under code of conduct issues, advice is so important because it is fully bulletproof. It protects you. And not only does it protect you, it also enables you to do the right thing in the course of action. So we're still talking about the role of an integrity commissioner. Janice and I happen to be lawyers, but we're not your lawyers. In fact, we're not practicing law any longer. We practice integrity commissioning. There's no solicitor-client privilege amongst us. That said, there is a statutory cloak of confidentiality. The statute says that unless there are some very narrow circumstances, what we do is confidential. Now, at the end of a complaint process, I don't want to mislead you. At the end of a complaint process, our obligation, if we make findings, is to write a public report. If we make findings and recommendations, is to write a public report. And we have the ability to disclose otherwise confidential information if we believe it's important for and necessary for a report to be understood. But by and large, what we do is confidential. So when you reach out for advice, the fact that it is you who reached out for advice, what your question was, what the answer was, is all confidential. Nobody will know about that. Not counsel, not the administration. All that is seen is an invoice with maybe an hour code advice, an hour 0.5 code investigation. Do you have a question?
Yeah. Does that work the other way? Will we, if this committee was challenged under the integrity or if someone had come to you with a complaint about someone on this, do you get to find out who it is that raised the complaint towards you?
Let me talk about the complaint process very briefly. If somebody were to complain to us about you, we would assess the complaint first of all, and then we would either forward it to you intact, or we would clarify it, make sure we understood what's proper, and send that to you and say a couple of things. One is, here are the four corners of the complaint. May we please have your written response in a couple of weeks? We're curious to know. And the second, and part of that would be the complainant is this person. That is confidential information that we have and we're sharing with you, and so you cannot share it publicly. But you would need that under the tenets of procedural fairness to assess the complaint. Okay. And ultimately, if we report out, we do not disclose that publicly unless the complainant is a member of council or a member of the leadership of the municipality, the CAO, exercising a leadership a role.
Jeff, if I may jump in, may I just add a couple of things? Because I'm aware that, for example, if I write to you with a question about code of conduct, that conversation is between you and I. Staff are not copied on that. The rest of council is not copied on that.
Correct.
That is an advice and information sharing between you and or Janice and myself. So it's very confidential.
Yep.
And I wonder if I could also ask you to speak a little bit to timeframes, because your turnaround is pretty quick.
So before we talk about timeframes, that conversation is confidential. I can't disclose it. But if you wanted to share the advice, you could. You're not bound by that confidentiality. So just to be clear, I wouldn't necessarily encourage it, but you're able to do it. As I said, advice giving is the most important function of an integrity commissioner. And so we target a 2-day turnaround, 2 business day turnaround. And we do better than that way more often than we do worse than that. That's how important advice is. It's a premium. We drop everything else in order to provide advice. It may slip here and there, but that's our target because advice is so protective. It's what really supports the level of trust you get from the community.
Thank you.
You're welcome. We're also independent, and in a nutshell, what independence means is that even though we like to be collaborative, work with council, members of staff and others, it means that, after our conversation, we may put up our hand and say, yeah, we hear you, but we're still going to do what we're going to do. Council cannot direct us. Staff cannot direct us. We are independent statutory officers. So we'll take a breath. Now we're going to be talking about code of conduct principles. Just the principles, not the text of the code. First of all, it's important to know that you are Once again, a local board, but you're a non-adjudicative local board. I'm not going to get into the weeds of this. Really, you could roughly divide all local boards into these two categories, maybe three, but we do it on this basis. You're either deciding rights like a committee of adjustment or perhaps a heritage committee. The matter is decided on the floor of the committee room. Council's opinions, the politics of council, no business to be discussed unless they're somehow shared as part of the record. They're all parties get to hear the evidence, and then the committee decides rights. Not making a recommendation to council, but there's a decision about rights. That's adjudicative. And adjudicative local boards have a bit of a higher standard than advisory, like yourselves, local boards. In the middle there, maybe not even cheating towards the advisory side, are operating boards, like the business improvement areas, and sometimes they're bodies that are charged with making decisions, exercising a function of council. Did I see you had a question? Oh, no, okay. So you're an advisory committee. Your role, no secret, is to advise. Recognizing the primacy of council, recognizing that it's council's role to take the input of your advice and a whole variety of other inputs and make taking all of those things into consideration, making a decision. That's what council does. But you are there to provide your best advice, and you're appointed to this body because you have perspectives that are going to be useful to share when you deliberate on the questions within your mandate. And you make recommendations, and staff will help you formulate those recommendations in a report that will be presented ultimately to council, or from time to time. I'm not quite sure how the governance is going to work, but certainly there'll be reports that are provided to council from this committee, and council will then have to make decisions on it, including the councillors that sit on this body. So when you have advice to give, by and large, you're going to be getting the perspectives from each other, from the members of council who sit on this body, and from staff. You're not asking council what your advice is to be. You provide the advice to council. You have that privilege of making your recommendations known right to council. It's a privilege.
And Jeff, I just want to add a comment, if I may, to that. Councillor Greenfield and myself are here as non-voting members, and we really are here just listening on behalf of council. And if there is any council-related question from any of the members of this committee, but this committee really is designed to be the public. We want the public to be able to comment and to make decisions and recommendations, and those will go back to council. We are here, but we're not meant to be, particularly influential in the discussions of this committee. This really is a public-led group.
Understood. And I would think that especially in the early days, to assist with process and giving some signal of the measure of the temperature of certain issues, that's your role. But members of this body have themselves an independent role. They're each entitled to a vote. They're each entitled to their say, and cumulatively, the committee will be making recommendations to council, including the members of council who sit on this body. Oh, I'm going to keep skipping that. So I'm not going to go through this in detail. The role of an adjudicative body is different, more formal than yourselves. Obviously, you have this deck, and if you have questions on the things I'm rushing through, ask them now, or you can review it afterwards. So in terms of the conduct aspect, this is not going to be a surprise to you. You've gotten this far in life. Practice the golden rule, be respectful. You learn the processes, the procedures by which the committee has to operate. You are a transparent body operating under the Municipal Act. Your meetings are in public unless you can, for some reason, meet one of the scheduled reasons why a body such as this can meet in the absence of the public. To the extent that there is some difficulty in the course of your deliberations, the best thing to do is to pause, maybe recess, let cooler heads prevail and come back to the table, because your discussions ought to always be respectful. Passionate, pointed perhaps. You can obviously freely disagree. It's not what I'm talking about. In fact, democracy requires that kind of participation, but always, always, always be respectful. Stay on point, fulfill the mandate, respect the role of the chair. I understand the chair has not yet been
Not yet
selected.
determined,
Right.
right?
So respect and assist the chair in conducting the meetings, and assist and respect people like me who may be standing before you, influencing your deliberations, members of council, members of the public, staff. Come to the table diligent, having prepared, exercise professionalism expected of you as a now publicly appointed official. I'm repeating myself, but you get the message. It's not hard to be compliant. You're going to be guided by staff. You know how to be respectful, and you can obviously, you're entitled to fully participate in the discussions. There are some constraints, of course. You can't exercise preferential treatment. You have to avoid what's referred to in the slide as real or apparent conflicts of interest. I'm going to talk about that in more detail in a bit. I'll talk about bias in a bit as well. And of course, the appearance of improper influence. Why? Because we have that mantra, we have that goal, which is to increase trust, respect, and engagement from by members of the community. The code of conduct itself, you should appreciate it as a guide. We're not trying to trap you into something. It's there. Now, the code is the same code that applies to, no, I'm incorrect. The advisory code is a little bit different from the council code, but it's quite structured. And it is to be read and to be understood, and it's your guide for proper behavior, not as a, please don't regard it as a trap. It's a guide because it provides you a guidepost for ethical behavior. There are discrete provisions in it that talk about conduct and your obligations to act with impartiality, to avoid conflicts of interest and that sort of thing. It's also a behavioral guidepost. So, you know, speaking specifically to the territory I just covered. And as a guidepost to fair treatment, because if a complaint is to come your way, it helps us understand how to process that, even though we will process it. And our highest obligation is to process it under the tenets of procedural fairness. So you get a say, we do a fair assessment, provide procedural fairness to everybody involved, that sort of thing. The last line I want to explain the line that says explanation of reasons. We have the ability, when we look at a complaint, to come to the conclusion that we are not going to investigate. Or in the course of an investigation, we have the ability to say, you know what? This is not the stuff that ought to be reported to council. It's been resolved. Somebody said sorry to somebody. That seemed to be fully the answer. They acknowledged a misstep, and the misstep wasn't so important that it needed to be daylighted to council. We end those matters by writing what we call a disposition letter. And a disposition letter, a couple pages, maybe 3, it says, here's what the complaint was at a high level, and here are the reasons why we are ending our investigation now. You have your reasons. That's the end of the matter. Matter's done. Instead of proceeding to council, because if of course we proceed to council on a recommendation report, our reasons are embedded in that report. So it's always necessary that somebody who in a position such as we are, an accountability officer, it's an important aspect of procedural fairness that we provide reasons for the decisions we make. So it's a guide, not a trap. Our goal is to focus on course correction where course correction is needed. We call ourselves, frankly, ask that you call ourselves coaches and teachers rather than cops and sheriffs, right? We want the whole classroom to do better. If somebody's stepping out of line, we may recommend you stay after school or run a lap after practice. That's the nature of the sanction. But the goal is to have this whole assembly do better if course correction is required. And so we do not treat complaints as litigation, even though we are legitimate actors in the administration of justice insofar as this little corner of justice is concerned, municipal integrity. We don't treat it as litigation. We treat it as a right-sized mechanism for serving the public interest. We're also careful to avoid being weaponized. So those who might choose to make a complaint to the Integrity Commissioner in order to collaterally attack you or a position you might hold is something that we look very carefully to avoid. Now, the reality is that a complaint will not be filed by your best friend. There may be political motivation to a complaint. There may be some collateral motivation to a complaint. What I'm saying is we don't really care. It's the quality of the complaint that we are going to assess and proceed upon. I know as I say all this, you're now thinking that you're all going to be subject to complaints every other day. It does not happen. It's not a regular event, but it's something you should be aware of as you embark on your journey that is the committee. Now, codes have principled sections at the beginning. It's appropriate that they do. It's appropriate that we give broad and liberal interpretation to the document in order to achieve all of which I've been talking about so far this evening. And I'm going to go into some of the changes that might be present in the code or our interpretation of the code in a few minutes when I talk about conflicts of interest. Are there any questions to this point? I know I'm moving quite quickly through this territory.
And Jeff, I would just say, if there's information that needs to be shared, please do that and don't worry about sticking to the hour as such. We allot 2 hours for this meeting. So I just want to make sure that everyone on the committee has a full, solid understanding because this information is really important. So don't worry too much about sticking to that time frame.
Well, thank you. Not having heard questions, though, I'm not going to move backwards into some of the detail I might otherwise provide. It's a good starting point. It's often the case, there's orientation that's given to members of council at the beginning of every term. And we politely try to decline being part of the originating orientation process because the reality is you're drinking from a fire hose and there's only so much you can absorb. So I teased out some of these things there. If you have concerns, you obviously can reach out. The municipality encourages you to reach out and take our advice. It's on Meaford's dime, not your own. And that's important because you have never been better supported, those who sit on advisory committees, than today with access to an integrity commissioner.
And I might add again, Jeff, if I may, just a word of advice. If you sense, and as Jeff said, it's very unlikely to happen, but if you sense that a complaint is going to come against you, it's always wise to reach out to Jeff ahead of time and say, this is the circumstance. This is, what I've been responsible for, what I've been involved in. And, you may hear a complaint in this regard, just so that Jeff has that prior information. I think it's helpful to him.
Absolutely. It is a collaborative process, even though we're independent. We may have a particular role to play if a complaint is to be filed, but nobody, including me, wants a complaint to be filed. Let's do what we can to avoid that. And one of the ways, the best way to avoid it is understanding your responsibility to avoid conflicts of interest. The Municipal Conflict of Interest Act is not going to receive a gold star for legislation. It's not It's not very friendly. It's hard to read. It's a bit peculiar in its approach. For years, it was perceived as the only thing that you had to look at to consider whether or not you had a conflict of interest or would have a conflict of interest. That's no longer true. I'll show you that in a minute. But one of the most welcoming things, one of the welcoming changes in the act was the introduction of principles. And these four were added to the statute, I think in 2017, maybe 19. I have the dates wrong, if I have the dates wrong. But there they are. And the first three you might consider to be pretty much expected, maybe boilerplate, your obligations to serve the public and their constituents in a diligent and conscientious manner, to act with impartiality and transparency, to abide by to make sure that your practices will bear close public scrutiny. You arrange your private affairs so that there aren't conflicts generated. Those are three principles you might expect. Number four is interesting, and I think it's particularly appropriate for the work of this committee. There is a benefit to municipalities when members, and you're a member, when members have a broad range of knowledge and continue to be active in their own communities, whether in business, in the practice of a profession, in community associations, and otherwise. Remember, this is a principle embedded into an act called the Municipal Conflict of Interest Act. It's a good thing that you have different perspectives. It's a good thing that you're engaged in the community, that you own businesses or participate on committees or associations. That's a welcoming thing. In fact, your terms of reference say that. We want you to have those perspectives. It's not disqualifying to have come to the table with that in mind. And so the principles offer guidance. So conflict exists only when it really exists. Whether there is an existing or a likely thing that will impair your ability to do the right thing in the course of the committee's deliberations. So now I'm going to pause. Now I'm talking about the statute itself. You heard the deputy mayor at the beginning of today's meeting ask for pecuniary interest, a declaration of pecuniary interest. That's a word that, first of all, is hard to say. Secondly, is not defined anywhere in the statute, but we understand it to mean a moneyed interest, a financial interest, something that can be reduced to dollars and cents. The Municipal Conflict of Interest Act only deals with money interests. Now, they fall into different categories. Direct interest. So, I'm inventing scenarios, obviously, but if for some reason this committee was talking about particular properties on a particular street and you owned one of those properties, well, that's a direct interest to you. Direct, likely a pecuniary interest, it's a direct interest to you, can't participate at that point. But it could also be an indirect interest or something called a deemed interest. And there is a requirement as well, it's hinted to in the code, to abide by the common law. So more than the Municipal Conflict of Interest Act. If you don't understand what I'm saying at this point, that's quite all right. We've got a bit of time left, and this is a complicated area. We want you to understand it well. So there's a statute, deals with money interest called pecuniary interest, could be direct, indirect, or deemed. So a direct interest, I gave you an example a few seconds ago. It's direct to you, it's personal to you. It's quite clear. Those are easy cases. Let's skip over deemed for a second. An indirect interest is can be one of these things. You're a shareholder, director, or senior officer of a non-public corporation that has the pecuniary interest before the committee. Okay, so it's a family corporation. The house isn't owned by you, it's owned by a family corporation. That interest, because you're a shareholder in that family corporation, it's a non-public corporation, that's attributed to you as indirect interest. Second example, you have a controlling interest or you're director or senior officer of a public corporation. Well, if that public corporation has an interest before the committee and you have a controlling interest in the public corporation, my first question is going to be, why are you sitting on this committee? You've got scads of money in your pockets and you could be on a yacht somewhere.
And we're so well paid.
The point is, of course, that if Bell Canada, just to keep it safe, if Bell Canada has an interest before the committee and you have some shares in Bell Canada, it's not a controlling interest in Bell Canada, it's okay. You can participate, even though Bell may have a financial interest in the matter. The Act says it's okay. If you're a member of a body that has a pecuniary interest before the committee, you have to step away. What does that mean? Member of a body. I was eavesdropping at the beginning and I heard people talking about service clubs in Meaford. If you're a member of a service club, let's say it's the Lions Club, if you're a member of the Lions Club and the Lions Club is coming to this committee and they want $500 to, I don't know, do something relevant to the, let's take it out of the committee. Pretend you're in council and the Lions Club's coming to council and asking for $500 for the Santa Claus parade. You are a member of the Lions Club. You are a member of council in this scenario. You're doing both. You're doing good works in both places, but you're a member of a body with a pecuniary interest. And so you must at council step away from the discussion. And, you know, in some provinces, there's an exception for service clubs, but in this scenario, money is scarce and the Lions Club and the Rotary Club and this club and other are looking for money. And it ought not to be the case that you're seen to be favoring a body on which you are a member. Now, we have some leeway to think about what membership is. Maybe you're not a member, maybe you're just a supporter. Years back, we had a question from Grey County Council. The member said, well, we're discussing the budget and there's a line item for museums and galleries and art galleries. And I am a member of Grey Roots Museum. Can I participate? And we said, well, I can see your membership card. It says member right on it, but it really is a prepaid user fee. It's not the kind of membership we're talking about here. And so we, as Integrity Commissioner, gave a green light.
Jeff, would this be the right time to ask you to also describe interest in common? Because that has come up for this council more than once.
Oh, no, it is not the right time.
Not the right time.
No,
Okay.
because we're heading there.
Okay.
We'll get there. You can see the breadcrumbs. Well, right now, actually, what I want you to do is think about these triggers for declaration under the Act alone. We haven't even gone into the common law yet. So, and the last bullet is a partner employee of a person with a body, a person or body with that interest. So that interest also could be attributed to you, if it's your partner or your employer that has it. Pretty clear, not hard to see why. In those circumstances, the Act would say you have to declare your interest and step away. Haven't yet considered the exceptions, just as, and one of which is what the deputy mayor mentioned. So we like to think of this as not pecuniary interest, declaration of pecuniary interest, declaration of conflict of interest, which is I chuckle every time somebody says I'm declaring a conflict of interest, because that, of course, does my work for me. You're not declaring a conflict, you're declaring an interest in order to avoid a conflict. But to make it clear, think of these things as disqualifying interests, whether they be triggered by the Municipal Conflict of Interest Act or under the common law, which we haven't really talked about yet. Think of these as disqualifying you from participating in a discussion before the committee. It's easier to wrap your head around it, I think, if you do it that way. So in our codes of conduct, the ones that we ask municipalities consider adopting, there are a bunch of rules, but we also include commentary. And I thought it would be helpful for you to hear the commentary, not the rule, but the commentary to explain the rule in those codes. Members should be committed to performing their functions with integrity and to avoiding the improper use of the influence of their office and private conflicts of interest, both apparent and real. Apparent being a sign that there's a common law responsibility. Members shall also not extend in the discharge of their official duties preferential treatment of family members, organizations, or groups in which they or their family members have a direct or indirect pecuniary interest. It's also true of common law interests. Members are governed by the MCIA. The Integrity Commissioner is empowered to investigate and rule on all conflicts of interest, whether pecuniary or non-pecuniary. Once upon a time, there was a school of thought amongst some that we couldn't deal with MCIA stuff, and I'm happy to say that's now acknowledged that we do have the ability to. When I seem excited by that, it means that we can treat these things in the same way as we treat code complaints. And if we can resolve them, we can resolve them. And only in the most egregious cases should we be thinking about going to court. Members may seek conflict of interest or other advice in writing from the Integrity Commissioner. Where members choose to seek external legal advice, they're not going to be paid for it. That's important because why? Your lawyer may not be expert in municipal law. How many people know lawyers expert in municipal law? You may know a real estate lawyer. But that's not the point I want to make. The point I want to make is when you get legal advice, it is an opinion. It is your counsel's view of what should be the case, your advocate's view of what should be the case. They cannot bind you. Sorry, their advice is not binding. They cannot bulletproof you. Only we can do that. When a member, despite the existence of an interest, believes that he or she may participate in a matter with an open mind, the public interest is best served when the member is able to articulate the interest and why the interest does not amount to a disqualifying conflict of interest. This is something I think in the fullness of time, we should be talking to the municipality about reviewing the code and introducing what we call transparency disclosures and an opportunity to daylight things that, you feel that target on your back, as I painted at the beginning, close call cases that may look like there's a concern, but do not rise to the level of disqualification. In those circumstances, it's helpful to be able to put on the record that this has occurred, because while you can say this in the chamber here, it doesn't get recorded because the clerk cannot write what's called note or comment into a minute document. By having it in a code allows it now to be registered. You can fill out a form, put it on your declaration registry, and sunshine will disinfect. It's a very useful feature. I can see the deputy mayor has a question.
No, I'm just agreeing, Jeff,
Okay.
and recognizing that you and I have discussed this before, and we need to make that change here.
Or it's an insertion into the existing code or review a new code. I think it would be helpful. So let me go on. Recognizing time limits, and I'm encouraging questions. We have plenty of time to take questions this evening. I'm nearing the end of the presentation. Think of this now as two different buckets. The Municipal Conflict of Interest Act bucket, where your direct interest, your indirect interest, or your deemed interest is a consideration. And then on the right, this common law consideration, where you may have friends and other and broader family class members or biases. I'm going to talk about bias in just a second. The one piece we haven't talked about yet under the MCIA, which is illustrated on this slide, is the category of deemed interests. So under the Municipal Conflict of Interest Act, which only talks about pecuniary interests, it attributes the indirect interest. It attributes to you an indirect interest of other people. Shareholders, we talked about that. And then it deems to be your interest the direct or indirect interest of certain family class members. So if the certain family class member themselves has a direct interest, that's an easy call. If they themselves have indirect interest and you know about it, it becomes your interest, essentially. And under the Act, who are the members of that family class? Your parent, your spouse, and your child. is there not a glaringly obvious omission there? Parent, child, spouse. Yeah. Brothers and sisters. My goodness. So that's our entry point into understanding that the common law also applies, even though a sibling wouldn't trigger the a municipal conflict of interest act concern. It is a concern. What would a person looking at your behavior on the committee say if it was your sibling that owned the house or was directly involved in the matter under consideration? You may love your sibling, you may hate your sibling, doesn't matter. There is an obvious connection between you and your sibling. And I would suggest to you with some authority that that can include friends and other family members. Not your run-of-the-mill acquaintance, but if it's your best friend that has the matter before the committee, the common law is going to say, wait a second, you cannot dispassionately make a decision about this matter without having regard to the closeness of the relationship. And so there's a test. I'm going to go through the test in a second to help you understand how you can think of your various relationships and whether or not they would interfere with your ability to participate. But before I do that, I'd like to talk about this concept of bias in that right-hand bucket, your biases. It's a cousin to conflict of interest, but it's important. It's appropriate we talk about it here. What's a bias? Let's say you are presented, well, let's say this. Somebody makes a complaint to us about your behavior. And I read this complaint and I go in my head, wow, if these facts prove to be true, this is a problem. If these facts prove to be true, there's likely going to be a report with recommendations for a sanction. Day one, I've done that. Am I biased? What do you think? Anyone?
Wow.
Pardon me?
The wow part.
You think? Yeah, it was a bit of a performance because I know my process. I know that procedural fairness requires me to reach out to the respondent and say, here's the complaint. What do you have to say? I know that there's still much work to come to interview people, to look at documents, to assess these things. I'm at point number 1 on our process map. And what I'm doing is saying, well, this has become interesting to me. I am curious what other information I'm going to come into possession of. I'm curious. And I haven't yet concluded that anyone has breached the code of conduct. I'm just starting. It's at the triage point, making me interested and curious. And that's the point. We should all be curious when we're presenting a position, because you have been put on this committee because you have a perspective. Most of you, I would think, you have a perspective. And here you are asked to digest the various pieces of information that come your way and the perspectives of your colleagues on the committee, listening intently. And here's the point, and being capable of being persuaded to come to a different conclusion. If you are capable of coming to a different conclusion, you may not ultimately come to a different conclusion, but if you're capable, you're curious, you want to know what everybody's perspective is, you're trying to find the path through this difficult morass, then you're not biased. And how do you exhibit bias? It's a cousin, because conflict of interest, I can look at the fact situation and determine whether or not there's been a conflict. Bias is subjective. Conflict's objective. Bias is subjective. Hard for me to look into your skull and see and examine how you think about an issue. And so the way you discharge an allegation of bias is by being performative, just as I am today. matters before the committee, you may be resolved about your perspective on it, but you ask questions, you voice why you believe what you believe, you exhibit that curiosity I've been talking about, and that's how you discharge a notion that you have been biased. You're in an argument with your next door neighbor over something and they raise their hand and say, I don't care what you say, it's X, Y, Z. Well, ding, 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 I don't care what you say. Bias. Of course you care what everyone else is saying. And that's an important consideration for members of council, members of committees across the board. This is not a new slide just for you, but it is especially pertinent given what this committee has been charged to do. It's an important consideration. So this test it is almost the same test as we would apply to determine whether or not you have somehow triggered a common law conflict of interest, known as the reasonable apprehension of bias. Testing whether a reasonable person, so that's a reasonable person, not a person on the street. This isn't the result of a poll. This is a reasonable person, reasonably well informed of all the relevant facts and circumstances, viewing the matter realistically and practically. It's not just a technical exercise, not for the municipal ethicist amongst us. Looking at the matter realistically and practically and having thought the matter through. What would that person conclude about whether you, as an appointed official in this case, were independent and impartial? Or were you institutionally or individually biased in the conduct of the matter? That's how you, so in the example earlier about friends and family somehow triggering whether or not you're conflicted, let me offer you two scenarios. This will involve a business property that your next door neighbor owns at the other end of town. If we're not right next door to you, you'd have other reasons for being directly interested, but your next door neighbor is developing property, the other end of Meaford from where you live. You're a member of council. That development application comes to council and you have to make your decision on whether you're going to support or oppose or with your vote this particular application. Scenario one, your next door neighbor, but occasionally you might pick up their mail their way and they might do the same for you. Very infrequent. Your relationship is pretty much the same as the people on the block or the next block. Nothing special. Scenario one. Scenario two. Your next door neighbor, well, their kids have no problem opening your front door, reaching into your refrigerator and making themselves a snack. You're talking over the back fence all the time. You might go camping and traveling together. You're Saturday night, one Saturday, you're at their house for dinner, the next Saturday, you can see a difference in those two scenarios. And scenario two, yeah, I would think that would give rise to the question, can you adequately separate your personal interest from your public duty when the relationship is that tight? Can you? Versus the first scenario where, yeah, I would think you could. Just next door, no greater influence. And this plays out in various other scenarios, and we can talk about those in a second. But so the whole point here was old school thinking. If you looked at this question of avoiding conflict of interest by only reading the Municipal Conflict of Interest Act, the MCIA, it was as if you're looking at the issue through a straw, because there's all of this outside the common law concern. So when you have one of these triggers, you have a disqualifying interest, you're obliged to do a couple of things. To declare the interest, here, you say it orally. I have an interest on the basis that I am a controlling shareholder of Bell Canada, and therefore I will not be participating in the committee's discussion this evening. That's your declaration. You cannot participate, you can't influence the discussion before, during, or even after it's concluded. So you're stepping away. You can't be talking to other members of the committee, influencing the outcome. You have to step completely away. You can sit over here in the gallery and watch the discussion so long as you behave yourself. You're not waving your hands and making grunty noises. But if the meeting is for some reason in closed session, you have to step away. And if you're at all uncertain, ask for advice, receive our advice in writing. We'll give you a memorandum and an advice memorandum to protect you and to assist you with dealing with similar matters in future. So it's reasoned out, you know how to do it. I'm still coming to the exceptions. There it is. There are a series of exceptions under the statute. We don't need to go through all of them. You know, one of them is there's a specific one that talks about council remuneration. So the only way councillors' pay gets approved is through the adoption of the bylaw. Every member of council is paid, and so it would be impossible to do that if there weren't an exception under the act, which allows members to make those decisions. For example, under the statute, there's also, well, if every year council adopts a budget. And we know that all members of council have an interest in land because they are qualified to stand for election. So when they pass the budget, that results in a levy bylaw that says we're going to increase, maybe decrease, likely increase taxes, which is a very clear pecuniary interest. And council, it would be impossible for council to make a decision except for an exception like this one, the interest in common exception. By reason of having a pecuniary interest, which is an interest in common with electors generally. So interests in common are they're challenging for us because we have to make a judgment call each time. We map it out, we rationalize why we land here or land there, why the public interest should allow this or shouldn't allow this. And the example I just gave was a pretty easy one. Let me give another one. That you're a member of council, let's say, and the question before council is whether to hardtop to convert a gravel road to an asphalt covered road. Happens to be your street. Hardtop your road, that's going to increase your property value. That's a pecuniary interest. Your road is a cul-de-sac. There are 5 houses on it. That's not an interest in common. Your house is on a 6-kilometer stretch of road with 300 properties on it. Yes, that's reached the threshold, as far as we are concerned, is a large enough segment of the community to qualify for the interest in common exception. So I'm sure there are other scenarios here that you might have with respect to whether or not you are disqualified from participating on this committee, particularly whether or not, including whether or not you would have or not have an interest in common with electors generally. Oops, and just so you know, when you look at this afterwards, you can understand, this helps you understand what the interest in common is when it's not applied across the board. But I've come to the end. I want to show you that there is a slide with our contact information on it. It's a rather long email address, but it goes to both Janice and I quickly at the same time, and it allows us to respond more quickly. You're going to be distributing the slide deck, I understand. It'll be made available to all members, correct? Yes. So you don't have to write it down, it'll come to you. But I am curious to know whether any of the discussion today has triggered questions in your own mind. You do not have to share them here in order to get an answer from us, remembering that you are entitled to confidentiality here. But to the extent that you think there may be some question that would assist, that you're a hypothetical or something else that you think would be useful for discussion today, I'm quite happy to take it. We've only taken up about an hour of your meeting so far.
Thanks very much for that, Jeff. Are there any questions from members of the committee? Lindy, please go ahead.
I was just wondering, I know you mainly talk just about the conflicts of interest when it applies to money or finances. Is there any other cases we should be thinking about, or is the act only applying to things that involve like people's money, finances, that sort of thing?
I thank you for that. And I think I neglected to explain the common law obligation better. And so it's quite clear that even though the Municipal Conflict of Interest Act is about cash, financial interests, the common law obligation is not necessarily. Common law, look at it this way, remember it this way. The test is, what would a reasonable person looking at it realistically and practically and having thought the matter through, what would they, and being reasonably well aware of all the relevant facts and circumstances, what would they conclude? Well, the reasonable person, of course, is going to know about the Municipal Conflict of Interest Act. And by the way, I'm the reasonable person in this scenario. It's the way we approach it. We're the ones that make the decisions here, and this is how we look at it. So the reasonable person, we are well schooled in what the Municipal Conflict of Interest Act says. We can do nothing about a provincial statute except to apply it. We may not agree that service club members should have to declare an interest for $500, but that's what the statute says, so we apply it. But we also look at the circumstances, like whether it's your next door neighbor. In that case, it may well be a pecuniary interest, but in other situations, you are looking at the issue from a, you have your own perspectives. You may have been appointed to this committee because you're on some other body that has a perspective relevant to the mandate of this committee. And the question might be asked, well, I'll put it this way, just to make it crystal clear. The body before me today is the Environment is Great Committee. That's what it's called. And you're appointed to the committee because you're on some other body that is very much in favor of protecting the environment. And somebody else is put on that committee because they're a representative of a development group that wishes to cut down all the trees and put subdivisions everywhere. They're on that committee. I'm hoping I'm not going to lose my train on this one. The common law is going to look at the entire situation. And let's put the developer aside because that could be reduced to a pecuniary interest thing. And that might make it easy. But somebody is an avowed environmentalist on this committee. Is it possible for them to at all agree with a proposal to approve or recommend approval for development? Is it possible? Don't know till I look at it. Just the fact that they come from that perspective isn't sufficient. If they're behaving in a way that shows that their mind is open and not biased, if their contributions to the discussion at the committee can lead to a consensus of some sort amongst all of the participants in the committee, then a reasonable person looking at the matter realistically and practically and thinking the matter through may well conclude that yes, they can make a decision in a way that allows them to support the public interest, notwithstanding their other relationships. So the short answer to the question is yes, your obligations need not be money oriented when you look at it from the perspective of the common law.
Thank you. Any other questions for Jeff at this point? Did you have another question, Lindy? No, okay. Yeah, and you've touched on it in so many ways, Jeff, but I just wanted to bring up the word perception because that is so critical, particularly in this small community where there are a lot of eyes on us, recognizing, as I say, explained in many, many different ways, the perception of an interest is something that we all need to be very carefully aware of.
Yes, it's the starting point. How is this going to be viewed by the public? Will we be criticized for it? It is the starting point. It may be, though, that in seeking our advice, and I know it sounds like an infomercial. I know I'm shilling for business here. I'm not. But it is vitally important that you be able to participate to your fullest ability, recognizing that sometimes you may have to step back, but for the most part, you're expected to diligently be at the committee and offer your perspectives. The public may perceive from time to time that you have an interest that disqualifies you. We don't know whether that's true or not until we look at it. So it's not just the perception that counts, but it is an important starting point for this. How is this going to look? Will it pass the smell test? It's not just that you might be criticized. You are expected to diligently participate in this committee, even though it might be a little bit icky because somebody might raise the question. But it's not just that. It's the starting point. If those circumstances exist, I encourage you to reach out and we'll, in the context, the factual context for the issue, will provide you advice. And then you can, with confidence, participate, or with confidence, know that you ought not to be participating, and will even word your declaration of interest for you. Yes.
Thank you. Councillor Greenfield?
Thanks, Deputy Mayor Kidney. On the subject of perception, there are different ways in which perception can develop. One is a particular situation where somebody misinterprets the what's going on, who's talking to who's rubbing shoulders with them, so on and so forth. The other thing involved with perception is quite often just simply misinformation. A rumor that's, somebody, that's not fortunately nothing much else to do. Can put two and two together when really there's nothing there to add together. But so perception can be so dangerous, and unfortunately it can snowball, it can mushroom, and especially in a small community, when there is a fairly serious issue in front of people. So I don't know how you handle that. You can't ignore it because sometimes it can come to the forefront and has to be dealt with.
Yeah.
I don't know. Do you have any suggestions?
I have two comments there. We didn't spend a lot of time on code of conduct issues. One of the issues, of course, is the engagement that you have in social media, because through social media that happens quite frequently, where there's a thread and there's a conversation and people misinterpret, or somebody twists, and I don't have to describe how social media operates. And it's not as if you're prohibited from engaging out there, but it really ought to be the case that if you use social media to take the temperature of the community, if you just to solicit information, that's okay. But everything should be focused to discussion here within the rules of the committee. So you're not, in other words, advocating for a particular position in that direction, outward from the committee. It should be brought into the committee for deliberation with an open mind, seeking some consensus on these very hard issues. That's not an answer fully. And this is going to sound a little strange, but if somebody's accusing you of something, misinformation leads to an accusation, it's not wrong to say, again, it's going to sound like I'm shilling for work, but it's not wrong to say this. Here's how you contact the integrity commissioner. If you've got a beef about me, I disagree with you, I'm not able to convince you, Still think there's a problem in my behavior, this is how you contact the integrity commissioner. There's a fair mechanism for these kinds of things to be resolved. And again, thinking back to the mantra an hour ago, which I paraphrased, that's one of the ways in which we increase the perception of integrity here by having a fair mechanism for disputes to be resolved. If only we could do that and not have all of the chatter and the fire setting and the things that tend to occur in social media.
I think we could have a whole training session on social media. Yes. Any other questions come to mind for Jeff at this point? Recognizing that you will have his contact information, and I would strongly encourage any of you, as Jeff has said, if ever anything comes to mind that you are concerned about, that you feel may be a potential perception of a conflict or an interest, by all means, don't hesitate to reach out to Jeff. That is exactly what he's here for, and there is budget for that interaction with Jeff. So don't ever hesitate.
If I may just add to that, you may not even know what question you want to ask. It may just be bothering you. Email us at postoffice@principlesintegrity.org. Hey, Jeff, I heard what you're talking about. I'm puzzled about this. Here's the facts. Do you mind if we talk about the issue? And we'll set up a time in Zoom or something. We'll have a conversation, and then we can follow that up with written advice if it's necessary. And the written advice is what bulletproofs you. Alrighty.
Then I will thank you so very much, Jeff, for making the trip up to Meaford and to share all of that very important information with us tonight. I'm going to call just a 5-minute break because it is awfully hot in here, just to give us a chance to get some air before we continue. So 5 minutes, everyone. I'm sorry. I know 5 minutes goes awfully fast and everyone is enjoying their discussions. I'm sorry to interrupt. Anyway, we will call this meeting back to order at 6:22. And the next item on our agenda is 6B, the election of chair and vice chair. So just before we get into that, and Bob is missing. At our last meeting, Bob was not able to be present. He was traveling, and we're just going to wait for Bob to come back because I just wanted to make sure that everyone knew Bob and that Bob knew everyone else before we got into the election of chair. So we're just going to pause and give Bob a second. Bob is the president of our Chamber of Commerce and very active in the municipality of Meaford. So we'll just give Bob a second. And there he comes. Bob, I was just saying that we recognize that you were able to tune in and watch the last meeting, but you weren't able to be present. And I just wanted to make sure before we got into the election of chair and vice chair that everyone knew you and you knew everyone else. So I thought I would just introduce Bob as president of our Chamber of Commerce. And Bob, just give you 1 minute just to say a little something about yourself. 1 minute. I know that's hard for you.
Yes, it is. So President Chamber of Commerce, 1987, I was President Chamber of Commerce in Orangeville. So I'm a rare double hatter, I guess. We had a business in Brampton, Ontario called Burfasco. And I opened 25 locations in total. Sold that business 19 years ago. I've been coaching small businesses. Came up to Meaford because the Thornbury Harbor was frozen one day and we couldn't put our boat in to go fishing. That was about 25 years ago. Fell in love with the community. I've maintained an office here for years, owned several different properties. My daughter has a business on Sykes. I've been coaching small businesses for years. I was invited onto the Dragons Den committee at one point, now in the Meaford Dragons. Coached contestants for about 8 years, including Adam. And it's been an interesting journey. So I have a sweet spot for small business and local. I have a good working knowledge of a whole lot of communities in Ontario. Certainly to open 22 Ontario locations, I had to research 50. I have checklists and things like this, and I do my homework on that. I'm really quite honored to represent the chamber. We have businesses that undoubtedly are for and against this project, mostly indifferent and wait and see. So we'll work through that. And I'm just pleased to be here.
And we're very pleased to have you here, Bob. And I'm glad to hear that most of your businesses are neutral or are open-minded at this point, because I hope that's how this committee will be perceived, is that we are in a learning phase, recognizing that we're here to be educated and to eventually make decisions and provide recommendations. But at this point, most of us are attempting to keep that open mind. So thank you for raising that.
Thank you.
So for your benefit, because I know you may not know everyone, we'll do just a quick, very brief round the table. And do you want to start off, Dave, and just tell Bob who you are? I know Bob knows you. Yes, you know Bob. Okay. And Lindy?
I'm the student advisory here, so you can tell by the age difference. I just turned 17, so my birthday was on Friday, and I go to high school in Owen Sound, and I've lived here my entire life. My parents are from, well, my dad's from Red Bob's not. My dad's from here, my grandpa's from here, his dad, and that's as far as back as I know how far it goes. I don't really know who's for that, but I really love it here, and I hope to give like good advice, I guess. That's, yeah.
Thanks, Lindy. Doug?
I thought I was the youth representative, but
Me.
so I've been a resident of Meaford since 2009, full-time resident since 2019, a cottager prior to that for most of my life, if not all of it. Welcome.
And Bob, I believe you know Harley? And and myself, Howard.
Hi, Bob. I'm Howard Fletcher. Have retired to Meaford in 2012. After I'm a career public servant, so I lived in Vancouver and Ottawa and Toronto. Ended up retiring in this lovely community and never looked back.
Jenny?
Well, Bob, I'm Bob Baranski. I've owned property here for almost 50 years in Meaford, and I'm a retired business person at this point in time. Happy to meet you.
Hi, Bob. Nice to see you again. But yeah, I'm born and raised in Meaford, involved in a lot of different service groups, community groups, things like that. Work and own sound, but live in Meaford and look forward to helping out this committee.
And Adam was really successful at Meaford Dragons, if I may say. Yes. Okay. Okay, that's a plan. And Bob, have you met Kirsten?
Yes, at the office a couple times for the interview.
Perfect. Okay, well, I just wanted us to all have that comfort level before we get into this next very important portion of the meeting. So what we're going to do, we'll elect the chair first. I will ask for nominations from the floor. It won't be either Councillor Greenfield or myself. We are, as you said, the non-voting members. According to the terms of reference, we could be elected chair, but I think it's very important that the chair come from the members of the public, just mostly for the perception that this is a public committee and that it is not controlled or unduly influenced by members of council. So the chair will be from the committee, as will the vice chair. So we'll have nominations, and after that, we will have a vote, which will be by a show of hands, and we will determine the new chair. And I'll sit in for the election of the vice chair, but then after that, I will change places with whomever is elected to chair this committee. Any questions about how we're going to move into this process? Okay, so I will open the floor then for nominations for chair of the PSAC committee. Adam?
I'd like to nominate Bob Peel to chair of the committee.
Bob, would you allow your name to stand for chair?
Respectfully, I think my time commitments are so tight, I don't know that I could fully commit.
And I appreciate that honesty, Bob. Thank you. Other nominations, Dave?
Yes, I'd like to nominate Howard Fletcher.
Thank you. Howard, will you allow your name to stand?
Yes, I will. Good, sir.
Thank you very much. I appreciate that. Other nominations, Jenny?
I'd like to nominate
Doug? Doug, will you allow your name to stand for chair?
Yes.
Thank you. And any other nominations? Going once? Going twice? Then I will call nominations closed, and we will have a raised hand vote for our chair position. Now, I'll open this thought up to the committee because it just occurred to me. Would you like to hear for a moment from Howard and from Doug as to why they feel they would be good chairs? Yes? Okay. Howard, you were nominated first, so would you like to take a couple minutes and just share why you would like to be chair of this committee?
Okay, well, my whole reason for being on this committee is because I wanted to have some input in this community, and I wanted to work together with other members of the municipality to make sure we're taking the right perspective and, being totally open-minded about the pump storage project. And I believe as chair that I can act totally unbiased and act with integrity and make sure that we all work together to achieve the same goal. And at the same time, I would expect the support from all of you to carry on in that role.
I appreciate that, Howard. Thank you. And I'll just add that whoever is elected chair will certainly have lots of support, both from Kirsten and other members of staff, and in any way that Councillor Greenfield and I can support, we are here to do that. Doug?
I mirror much of what Howard said. They're probably the same reasons why we're all here wanting to participate and make the municipality better. I certainly have experience on board of directors. I'm vice chair of two companies now, and have been for the better part of 6 or 7 years now. I certainly have time and availability. I am here most of the time, and happy to take on the role, and would also look forward to everyone's support.
Thank you, Doug. Okay, any questions for either Howard or Doug? And seeing none, okay, so we're going to have a raised hand vote. Howard was nominated first, so those in favor of electing Howard? 1, 2. 2, okay, and those in favor of electing Doug? 1, 2, 3, 4, and 5, and I'm recognizing that Harley and I are not able to vote. So Doug, you are chosen as our new chair. Congratulations. Oh, yeah. And you think this group has been nice. Yeah. Okay, so we will move from there into nominations for vice chair. So I'll open the floor up. May we have a nomination for vice chair, please? Bob?
I would like to nominate Howard for that.
Howard, would you stand for vice chair?
So well.
Thank you. Any other nominations for vice chair? Going once. No other nominations. You can nominate yourself if anyone would like to stand and put their name forward for that position. Okay, seeing no other hands raised. Howard, I will say congratulations. You are now vice chair. Wonderful. Wonderful. Okay, so I am now relieved of my duties, and thank you all for allowing me to sit in this role for the first meeting and a half. But as we've stated, it was always intended that this committee will be chaired and led by members of the community. So I will now relinquish my chair to you, Doug, and I will come and sit where you are. Oh, absolutely. Would you like, if you like, do you want Harley to move into your chair and I'll sit next to you and then I can sort of guide you through the rest of the meeting? Okay.
Not really.
Okay. So I just. So I will, you've got your agenda. Okay, so we'll move next into C, meeting plan and future meetings, and Kirsten will lead that discussion.
Thank you, Kirsten.
Thank you. We'll just wait for, there's a PowerPoint to,
You might need your water.
okay. So I am going to give you a quick preview about what we can expect in future meetings coming up in July and then for the next quarter or so, so you can best prepare. I'll go into detail about July's meeting, but I do want to disclose that this is tentative. So there are some scheduling details that are still to be finalized. But again, we wanted to give you a preview so that you can come prepared. So what we see for July is having an impacts, benefits, and opportunities discussion. So now that we've completed some training, we can move forward into identifying topics that the committee is interested in exploring. So we can expect meetings to be around the 2-hour mark going forward, just for your own planning, unless otherwise communicated, which I will do in email in advance. So in order to facilitate this timing, we thought it would be best to have this discussion as its own meeting. And we want to make sure there's enough time for everyone to equally contribute and have that opportunity. For August, we see a further discussion about these issues and a presentation of consolidated findings from the July discussion. We'll use this to identify topics and expert speakers or organizations of interest to attend future meetings. And then going forward into September, which is crazy to think about how close it is already. We understand that it's important to hear about the project from TCE themselves. So we can tentatively expect them to provide a presentation on the project at our September meeting. And then lastly, we're hopeful to hear from the Impact Assessment Agency of Canada. So that will be for October. And I can go into detail in a few more slides, but the regulatory process is important in this whole project. So we want to ensure that any questions or concerns that might be answered from that organization can have the opportunity to be addressed as well. For all meetings, the official agendas will be published a week in advance, as we've had the past couple months. So going to July meeting, we'll start off with a review of the meeting objective, and we're excited to have Becky Smith facilitate the meeting. So Becky was here at our last meeting, and she is a member of our Ainley project manager consultants, and she has vast experience in facilitation and communications. So the objective of the meeting is to bring forward any impacts, which can be grouped as positive or negative, benefits and opportunities related to the project. So the goal of the structure of the meeting will be to make sure that everyone has equal opportunity to contribute. So please keep an eye out in the next few weeks with more details about the format of the meeting. With this in mind, it's important to remember that there's no wrong answers. So not only think about topics of interest, but also share details and questions you want answers to. So like I said before, the information presented in July will be used to help guide future meeting agendas. So there's still a lot to learn about the different areas of interest. So for transparency, timing and major milestones of the proposed project will also play an important role in future agenda development. And some recommendations or things to think about here before our next meeting. The different phases of the project, so as a whole, so pre-development, construction phases, and operation. Review the committee's terms of reference, and then specific details will be really important. So for example, if an impact concern is the environment, which part? So if it's fish habitats or species that are on the base, all those details will be really helpful to bring forward. I think we briefly mentioned this at the end of last meeting. Speaking with your network is a great way to source impacts, benefits, and opportunities. It could also be useful to get a refresher on the proposed project details, the different phases of the projects, and any questions you have related to that. And then again, the regulatory processes that are associated with the project. This slide is some areas of interest that have been identified and put together. So the topics that are listed here might be of interest to this committee as well. So something to get the ball rolling. And I can provide these to anyone after the meeting too, if they are interested in writing them down. So going into the regulatory process, I just wanted to give a quick summary about what they entail briefly, very briefly, just as they relate to areas of interest to the assessments. So the Ontario Environmental Assessment, also known as the EA, plays a crucial role in determining if the proposed pump storage project can go ahead. It evaluates all these different areas, including effects on local ecosystems, water quality, wildlife in Georgian Bay and surrounding areas. So these are detailed studies, and they also talk to the public to ensure that any environmental concerns are identified and addressed, leading to any necessary mitigation measures. The next regulatory process that I wanted to bring forward as well as something that you might want to look into before the July meeting. And there is a lot to look into with these processes. Both the environmental assessment website and the federal impact assessment websites are really great resources and have a ton of different tools to learn about them. So the federal impact assessment process evaluates how TC's pump storage project not only affects the environment, but also people and the economy. So this process looks at how the project might impact federal lands, water, indigenous communities, and different types of plants and animals. And so this little figure or image was taken from the federal impact assessment website. And you can see that there's a number of different stakeholders listed at the bottom. So there are quite a few different key points in this assessment. That wraps up my preview for July's meeting. If you have any questions, I can do my best to answer. And if I do not know the answer off by heart here, I'll do my best to source it and get back to anyone. Yeah, any questions about that? Yep.
Thanks, Kirsten. Looks like you've been busy.
Yeah.
That's great. That's great. Looks like a lot of material there. Areas of interest. I personally have one that is municipally related that wasn't on your list. I'm assuming there would be an opportunity to bring that forward at a later meeting.
Yeah, so the areas of interest is not complete, and this is something that we think that the committee will talk to you about, but these are different areas with different reports that have been identified in this process that mainly the project consultants will peer review. So I thought that those reports would be a good way to get things rolling here. So
it was a very good list.
I can't take credit for the creation of it. So
I do think it's really important before our next meeting that we actually have some of the environmental assessments and the project specs from TCE, so we can make good sound decisions and review that material, because what we're bringing to the table will be affected by that. If something doesn't exist in the plan, there's no sense us talking about it. So I think it's really important that they send like drawing specs, an actual map with actual diameters, all those kinds of things, so that we can make sound decisions. So I think we should, it's of utmost importance, like even before their presentation, for them to provide data, is my opinion.
Thank you, Chair Haslam, and we can certainly ask for that, Ginny. There's a lot of information that they don't have yet until the environmental assessment process begins, but we can certainly ask them, I think, to share what they do have that is pertinent to our discussions. And I just thought I'd add, we're working under the assumption that the project is going to go forward into the IA phase. I mean, it may or may not. July 31st, as far as we know, is still the deadline for the ministry to provide that green light or red light, whatever they choose to do. And I think everyone will be aware that there was a shuffle last week, and Stephen Lecce is now the new Minister of Energy. So that may put a little delay into things as he gets up to speed, but I think it's expected that that won't take very long. So we'll, if something happens and he decides this project isn't a go, then things do not go forward for us or for Meaford or for the project or anything of that nature. So it's a bit of a wait and see, but we do have that meeting in July prior to that deadline. So we work under that assumption. And I think, Kirsten, if you're comfortable, we'll ask TC Energy to provide us any information as Jenny has referenced.
Yeah, definitely.
Question? Bob, can you turn it? Thank you. So, Kirsten, I was just wondering, is it possible for you to find out whether they would actually do both an EA and the federal one? I would think that they might just meld them together. That would be interesting for us to know whether there will be two separate one's federal impact and the aid from the province, or whether they'll melt it together.
Sure.
Thank you.
Definitely confirm for you.
If I may, Chair Haslam, my understanding is they will be separate.
Adam?
Will we be hearing from the military at any point?
I believe that is up to us. And so I think if that is something we want to do, then we should make that as part of our process. More questions?
I guess kind of adding to that, I know you talked about us kind of hearing from TC Energy, so that would definitely be one side of kind of the decisions we have to make. Will we be hearing anything from any like the organizations locally that are the opposite, kind of very heavily against it, just so we can have a nice balance, just to make sure if we're bringing in outside organizations, it's not just one opinion, or is that something that's still to be decided?
Again, I think as a committee, that is up to us. I would think that if we are having proponents, we should have detractors just to get a balanced view of what the lay of the land is. And we probably don't want to delay till October, November. You know, it's going to be difficult for us with 2-hour meetings once a month, but I think it's important that we do that.
If I may suggest, Chair Haslam, we do have our deputations and presentations as part of every meeting agenda. So we certainly could hear from Save Georgian Bay people in the impact zone. Anybody who wishes to speak for or against the project is welcome to attend any meeting. So I think it behooves all of us to talk to people that we know in those groups and encourage them to make that known to Kirsten and get on our agenda.
There's no other questions. Because of our July agenda, if you know that you can't make it, please let me know. We just want to make sure that, we have everyone here to contribute to the discussion. And that goes with every meeting. So as things come up, if you do know that you have a commitment that you can't make it, please let me know as soon as you know. I think that's it. Yeah.
Kirsten, as part of that, will you send that short presentation out to all of us sooner rather than later?
Sure. Yeah. For reference.
Yeah.
Yeah.
Thank you. Adam?
And speaking to that point, are we able to, if we are not going to make a meeting, submit anything in writing, any questions or any comments that we want to have brought up in the meeting?
Yes.
I don't see why not.
Yeah, I don't think there's any reason why, we want everyone's participation as much as possible until we solve the insurmountable connectivity issues so that we can Zoom this. I think if you know you're not going to be there and there's points that need to be made, then absolutely please forward them. Well,
I can suggest, having missed a meeting already, that the presentation over the video over the internet in Kelowna was perfectly fine. The meeting was clear. The camera work was fine. I don't feel like I missed very much of anything at all. Maybe a couple of sides, but that was about it. So having missed a meeting, I feel like I still participated. And that might be, some guidance. I do have a trip to Antigua in November. And I can tell you the internet down there is spotty as can be, but the recorded version will work in its absence.
Councilor Greenfield.
Thanks, Chair Doug, through you to Kirsten. The presentation from TCE in September, and there's no doubt about it, we need to get the company in front of us as soon as possible. We talked about 10-minute presentations and so on and so forth by basically anyone who signed in at the meeting. I'm assuming this TCE presentation is going to be much longer than 10 minutes. Am I correct on that? And I guess that leads me to my next question. If that is the situation, I'm trying to get balance here, and 30-45 minutes doesn't balance with 10. just something we may have to work on in the future?
Yeah, so like I said, the plan is tentative. So if we get feedback, I mean, I don't know how long the presentation would be that TCE would give. And those might not be the only items on the agenda. So if we have other items to add, then that would be one way. But yeah, like I said, tentative schedule, just so that we can see going forward and have a preview into what's to come.
One more question, different subject, if I may. These meetings are always going to be the second Thursday of the month. Is that the schedule? Okay, I just wondering, it's fairly customary for council to disappear in August, so I'm not sure the deputy mayor's plans, but anyway, we'll deal with that in a month or two.
I think in what Harley's trying to say, so if we invite a group to come and speak to us, be it Save George and Bay, TC Energy, anybody, they shouldn't be bound by the 10-minute. Isn't that what you were trying to get at, Harley?
Yeah.
Yeah. Which is only fair. Yes.
And again, I think we can, as the committee, can agree, and it shouldn't be an open-ended invitation to present until we are all asleep. But certainly we can say, hey, listen, we want an in-depth presentation from this group and ask for more time and allot it.
Just to follow up on the hybrid meeting Zoom topic, I've done a bit of research on that, and there is procedural bylaw that says that it has to be in person. So if this committee wanted to have it be hybrid or changed, there would have to be a motion that the committee votes on, and then that would be added to council's next agenda. So that would be how the process would go from here. So I know that was brought up, and I just wanted to provide an update on that.
Being fairly new to this role, is that going to be possible? Can we do that? Ask for a bylaw change so that this committee can participate in meetings remotely?
If I may, Chair Haslam, I know staff are working on the challenge. It's not simple out here. The internet is not good. Staff struggle here. They can't even within the office all be, trying to download something at the same time. The internet quality is very poor, but I know, and Adam will know more about this than I do, but we are working on solving this issue, first of all, to make internet capability better for staff and to then move into the opportunity for hybrid meetings, because we'd like that as a council as well. It just has never been possible, and it will take some investment. So we're definitely working on it.
Is it helpful if this committee requests it formally?
I think most all of the advisory committees are asking the same question. So I think there is definitely feedback from members of the public that it would be a real advantage to have that option. So I think that certainly moves the request up the ladder to get this looked at. But I'll follow up with staff and try to bring some news back to the next meeting.
Good. Adam?
Through the chair, curious, does each committee have to request this, or is this one committee does it in a bylaw and everybody gets to take part in it?
I don't know if it's every committee, because I just focus on this one. But to follow up and circle back on what Shirley had said is that the procedural bylaw is what the committee would vote on, and then that would be brought to the council agenda. But then that being said, it wouldn't necessarily mean that we would be able to address the challenges. It would just mean that there's that procedural part of it that would need to be looked at first. And I'm not too sure on the spot here if it would.
If we moved that motion now and allowed for whenever technology allows for it, is that still something that can be done?
I think we can have, sorry, Shirley, go ahead.
Thanks, Kirsten. Thanks, Adam, for your question. I think my suggestion would be that we recognize that's the desire of this committee. I know at least 3 other committees who have the same desire, that we take it back and bring forward a notice of motion at the next council meeting requesting that this be given more of a priority by staff and that we get that report and understand what we're looking at, how much the investment's going to be, is it possible at all, what has to be done to bring hybrid capability here. So yeah, we will amp that up.
Is there any other business for us? All right, our next meeting is July 11th, at 5 o'clock. We'll see everyone there, I hope. Meeting adjourned.
Okay.